everything is also contract. So you have to have an enforceable contract. Anyway, putting all these different thoughts together made me realize that, hey, I had really been focusing much too, I've been putting too much emphasis on, let's say, the instrument, the bill of exchange, or the bond, or whatever the instrument was that I was using to discharge. I think, I was focusing more on that when probably more important than the instrument is the actual contract. Why? Because in reality, it might be an error and it might set us up for failure if we really think and continue to think that the person receiving the correspondence is going to be an honor and be an acceptance and actually discharge your mortgage for you and send you the certificate, et cetera, right? So if I'm telling you that the majority of the times that's not going to happen, but I think it will a few times, but if I'm telling you the majority of times it's not going to happen, well, why do we continue to move forward and do it anyway? Well, to answer that, it's about first, being on the right side and not being on the wrong side. So I'm saying, whether I can't predict what the fiduciary is going to do, but I am going to cross all my T's, dot all my I's, do my due process, and lawfully discharge the debt. Whether they want to oppose that, be on the wrong side of the law or the right side of the law, I can't predict that. And that's not the focus of what I'm trying to share with you, or dare I say, teach you. And sometimes it makes me frustrated, and maybe I can communicate to that people here right now, right? We can't predict what they're going to do. Of course, the goal is we want to have a success, but maybe we have to, sit back and think to ourselves what constitutes success. Because if they refuse, deny, object, ignore, your bond, your bill of exchange, your instrument, or whatever, then what are you going to do next? Because if you do nothing, that's what it's all set up for. So then now you lose, right? So that predicament in part will cause you to have to go back and really study really hard to understand, when you're giving a bill of exchange or a bond or anything else, is this lawful, what you're doing? Not just because other people were doing it on the internet and there's no money and it sounds good, but can you stand on it if nobody else could help you and give you any references or anything? Can you stand on it? Are you convinced and convicted that this is the right thing to do? And can you foundationally support that in law? Can you stand on it? And this is how I'm trying to bring the research, especially when it comes to discharging debt. It's not a thing about, oh, that didn't work. Well, it doesn't work for somebody, might work for somebody else. And what really is to be said is that you didn't have success. I hate to say that you were defeated, but in many cases it's because you were defeated. So what I want you to understand moving forward as we go through the rest of these discharge mortgage videos is, I'm trying to share with you my research and what I've done. I'm not telling you, matter of fact, you do this and it's going to work. I'm showing you what I would do, or what I am going to do or will do if I'm in this situation and it doesn't work. Because I can't leave the battlefield. I have to keep moving forward. So what can we do if we've done everything right? We did all our research. We put the memorandum of law together. We gave them the bond, and we gave them fiduciary appointment and authorization contract. And we said, discharge this in 72 hours and record this release and satisfaction of lien. And we know we did it right because we heard texts talking about it on the internet. And then they just sent it all back. They just ignored all of it. What are you going to do? Because it's probably going to happen, right? And I'm glad you asked. So now, so ultimately your enforcement is breach of fiduciary duty and proceeding against the surety bond. You look up Freedom of Information Act in your state, and they have these laws that you can use, and you can send a letter, and they will give you the bond, the insurance information, and everything. What I will share with you is, just because you know you can get that stuff, don't just go out there and get it. Don't even get it until you need to. The majority of you are not ready to go proceed after somebody's bond. You don't know enough. And you should not try to do this stuff if you don't understand and you don't know enough. Keep seeking and studying until you feel comfortable and you get the information. Remove the emotion of it. You want to go after the bond because they made you mad. They made you mad and they disrespected you, and it just doesn't feel right. But you really, you couldn't assert any constitutional right because you don't even know what the constitutional rights are, right? So if you're like that, be a bigger person and say, I got to step back and learn. Some of this information is for people who are, they already understand and comprehend and just haven't been able to, they're just stuck at another little angle. So there's all kind of people that listen to this. Don't bite off more than you can chew. All right. Because this stuff right here, what we're talking about now, when we start talking about going after a public official's surety bond, that can blow up in your face if you didn't cross all your T's and dot all your I's and you can't stand on what you've done. If you can stand on what you've done, they have a big problem on their hands. And I hope that you can get that, you can comprehend that, and you can see that. That's what I'm trying to get you to understand. Because we record a bond or we present a bond, you know, whether they accept it or reject it, it's not about that. It's about the law being fulfilled, right? So again, more important than the bond and the instrument, in my opinion, is what we're about to look at today, which is the fiduciary appointment and authorization contract. That's more than just a Form 56. This is actually the contract that you will use to enforce your claim on the surety bond. At least this is the way that I set it up with my research. This is the way that we templated it out. And again, if you want access to all the templates that I've done, create your membership on thctrust.org. So we're over here. We're going to go down to advanced topics. Click the mortgages. This video would be right here. It was 1 of 7, so I think this is video 6. Yeah, we have 5 videos here. So this is 6. And this one we're going to talk about the fiduciary appointment and authorization contract. I'm going to skip over your presentment, whether you have somebody, but some ideas is you can have somebody deliver the presentment to the clerk of court, have them sign for it. You can mail it registered mail. You can walk it in with a witness. I mean, you could figure out how you're going to present it. The general standard way is registered mail, restricted delivery, and I'm gonna skip over that because you can look elsewhere of how to present your documents or your instruments. But we're going to look over the substance of the fiduciary appointment and authorization letter. And man, I gotta say this. I don't know if I said this in the last video, but here we go. Where we at? Sorry. Check this out here. The county recorder is a constitutional officer. So Google that. Google your county recorder or just Google constitutional officer and just read and familiarize yourself with that a little bit. Because again, we're dealing with the pledge to support and defend the Constitution. So the way I see that is this puts you under a specific umbrella, a specific set of laws, if you will. Because we know they got different jurisdictions, different state administration and, straw man stuff, all these different things, how they administer property in these counties and these courts and things like that. But under the Constitution, that's a special jurisdiction, if you will. It's not what they're doing on a consistent daily basis, obviously. So the county recorder of deeds is a constitutional officer, which is the reason we charge them with the duty of discharging the mortgage under the law. The nature of the constitutional oath and our fiduciary appointment and authorization letter creates a security interest in the public official's surety bond, which is our leverage and the reason we expect any law-abiding officer will perform. Any default on the discharge results in a claim being made on a standard Form 95 for a tort, which is breach of fiduciary duty. Man, that was right on the website. Like, man, it's great because I was thinking like, I got to make sure I give you guys the right information. I already wrote it. So this is the way that I'm seeing it, right? The fiduciary appointment letter creates the security interest in the public official surety bond. And that's also supported in the UCC, in the Uniform Commercial Code. Did I put that in here? Where? Okay, no, I didn't put the actual statute in there, but that is supported in the UCC. The acceptance of the oath covers the proceeds, which is the surety bond, and you have a security interest in that surety bond while the fiduciary is required to perform. And I was saying bring that on a standard Form 95. Now we're just kind of ahead of ourselves looking at if we had to go to enforcement because they ignored everything. Now standard Norm 95, people say, well, that's for the federal government. Yes, it is, but we're dealing with him in his fiduciary capacity as a constitutional officer under his oath. That makes them a part of the national government. So specifically, since the bonds or the instruments and everything, they have to deal with the Bureau of Public Debt and the Treasury or wherever else you can think of, including the IRS. These might be the reasons or the departments or the agencies, that you send the standard Form 95 to. Anyway, you use your sunshine laws, your state sunshine laws. That's the access to information laws. As I always state, you write them a letter, you request the surety bond. That's all you need to request, just the surety bond. You don't have to really get more than that. And then you may also send them a W-9, a request for taxpayer ID number, in that same envelope, if you will. Here's an example, just one simple example. I always show these examples. Dear Keith, whoever, or to whom it may concern, pursuant to Sunshine Act 65, I am requesting you provide a copy of the oath of office as required by 53 PA subsection 1141 and a copy of any bond or indemnity policy by whatever name that accompanies, by whatever name that covers Sheriff whoever of Pennsylvania. So this simple letter, you ask for directly what you need, let them send it to you, and get all that information together before you get started. You know what I'm saying? It just makes more sense. Okay, now that you have that, now let's go into the fiduciary appointment and authorization contract. Where's that? Here it is. We pull it up on the screen here. Now let me give you, before we look at each page, let's just do a quick overview. This is a cover page. This is the actual notice. This is the contract. You can't see it yet. We're going to zoom in. Fiduciary appointment and authorization contract. Contract is 3 pages, right? And this is an attached memorandum of law. These are the laws that I put together that are in support of the appointment for the fiduciary to discharge the mortgage in full acquittance and record the satisfaction instrument. So we're appointing him as our lawful fiduciary to perform this discharge for us as a matter of law, and we've given him this memorandum of law so that he has notice of all the laws that we're relying on to do this. Why did I do that? Because a little research I was doing into how to remove immunity, right? There can be we didn't know about these laws because I provided a whole list, a page and a half of the laws. right? So this is, as I said earlier, I think I said, at least in one of the earlier takes when I was making this, I was stating that this fiduciary appointment and authorization, in my opinion, is much more important than the actual bond, bill of exchange, or instrument itself. And so many times we've overlooked that, and when they've ignored our presentments or our instruments, we had nothing to rely on because we didn't have any enforceable contract. So this is our enforceable contract, and we're going to read through it and see how it is. So I'm going to start at the top here. This is the cover letter. Again, the cover letter is because the way I see this is your constitutional officer, recording officer will receive this cover letter, and inside of an envelope that has another envelope which contains private documents. Those private documents would be like your surety bond, for example. That'll be a private document. This cover letter can be a public document, as well as your release of lien, discharge of mortgage, satisfaction of mortgage instrument that gets recorded in the county. Those could all be public records. But those can be in the first envelope, and then you'll have your private records, you know, the surety bond, as well as this fiduciary appointment and authorization contract. These is part of the private records. Okay, so this is just thinking this out loud, kind of, right? Dear Diane Schwartz, Humbleton County Clerk, I am John Alex Doe, a native New Jerseyan and trustee for the Anna Doe Trust. Don't get wrapped up on that. So in this case, as you see, this is like John Doe doing this for somebody else. I need to change this, make it simpler so it don't confuse you. But anyway, I am requesting your performance with regard to recording the discharge of mortgage instrument provided herewith and supported by the enclosed fiduciary appointment and authorization contract and memorandum of law. Please record said discharge instrument no later than, give them a specific date. Why? I like to give thresholds and dates so that there can be no ambiguity that you're in default. Because it's not like, oh, we just didn't do it yet, or no, you were supposed to do it by the 27th. You're in default. No, that's how I like to do it. But anyways, I have enclosed the United States Postal Money Order for the sum of $61 to cover the cost of recording and returning a certified copy of the recorded discharge of mortgage to 26123 Avenue, etc., etc. Okay? That's just the cover letter. Now, I put a privacy notice on there. Privacy is required by law. Any information you receive related to this contract or transaction is to be held in strict confidence and privacy. These presentments contain proprietary methods, which are trade secrets of the Anna Doe Trust. The documents, methods of trade, techniques, processes, instruments, and procedures are confidential and protected by law, including but not limited to the Economic Espionage Act of 1996. You may not copy, photograph, scan, duplicate, or otherwise disclose any information contained herein except as required by law and or for lawful purposes as set forth. Nothing in this notice is intended to restrict or limit any person who is operating under delegation or subdelegation of authority or fiduciary appointment from exercising discretion, and as long as such discretion is made in good faith. The fiduciary is indemnified when disclosing information as required by law or otherwise necessary to carry out the instructions provided with with the appointment and authorization as set forth in the fiduciary appointment and authorization contract. All right, that's my privacy notice. Here's the contract in regards to discharge or release of lien on security deed number, whatever, mortgage book page number, whatever. Fiduciary appointment and authorization contract, whatever. That's the number. The registered mail number. Power of authority. I, John Alex Doe, for the Anna Doe Trust, doing business as Anna Doe, the principal being duly sworn, depose and say that I have the authority and broad general power of attorney to grant, convey, assign, pledge, and authorize all of the sureties, assets, duties, etc., etc. We're going to skip over that. Let's go to the next section. Collateral, acceptance of oath, performance guarantee. The principal accepts your oath. The principal accepts your oath of office, the pledge of Diane Schwartz. Let me read that again. I got to correct that. The principal accepts the oath of office or the pledge of Diane Schwartz given on January 1st, 2019. and the related surety bond number B123456. Now you will be able to put the surety bond in your fiduciary appointment authorization contract. Why? Because you already did the open records request and you got that information back. So now you're making it real clear the collateral that you're attaching your security interest to, just in case there's no performance, right? Again, this bond is going to probably be 50,000 or 100,000. The bond that you're tendering to discharge the mortgage or whatever you're doing is probably going to be $500,000 or more than that, right? So is there any misappropriation of those funds if they get rejected and dishonored? Is there any liability on the fiduciary's part? Yes, because we established that in this contract, as you'll see. So let's read that again. The principal accepts your oath of office, or accepts the oath and the pledge of Diane Shorts given on January 1st, 2019, and the related surety bond number 12345, held by Selective Insurance Company of America as collateral to guarantee that the fiduciary will not derogate from the Constitution or the laws of the United States of America as referenced in the memorandum of law. Again, the memorandum of law down here just has, we started with U.S. Constitution, Article 1, Section 10, Clause 1. No state shall enter into any treaty, alliance, or confederation, grant letters of marque. Also, that's not what I was looking for, but also check your state constitution. Add to this memorandum of law, especially laws relevant to the instructions or the appointment that you're giving. In this case, in New Jersey Constitution, as well as I believe the California State Constitution and other constitutions, talk about your fundamental right to possess and protect property. So these are also constitutional rights or laws that you want in your memorandum of law. But anyway, the first thing we did is we accepted their oath and we accepted the related surety bond as collateral for the performance guarantee that they will not derogate from the laws of the United States. Now here's the appointment and authorization. Notice, let me note one other thing. When you read through this contract, the only time I mentioned the clerk is right here. I put Diane Schwartz, constitutional officer, and I put in parentheses here her position as a county clerk because it's kind of irrelevant to this contract. This contract is a fiduciary appointment based on her oath, not the county's oath, not anyone else's oath. So I'm not really trying to bring them into this business. Although you probably will get a letter back from the county attorney if you do something like this. Okay. But just, so you can put everything in its proper perspective. Don't get wrapped up in the county game. You're not fighting a battle with the county. You appointing this specific person as your fiduciary. The principal hereby appoints Diana Schwartz as fiduciary to take care that the laws be faithfully executed under this contract, and hereby transfer the power and legal estate provided herewith to dispose of in the manner set forth in Section 5B2 of the Trading with the Enemy Act of October 6, 1917, Chapter 106, 40 Stat 411, requiring discharge in full acquittance, and the transfer of assets in accordance with Section 3113A and 3113E2 of Public Law 97-258, September 13, 1982, 96, etc., as a gift to reduce the public debt of the United States. So I'm telling the fiduciary that I am lawfully transferring you this property, which is the bond and the certificate of title that's associated or connected thereto. And I keep saying bond, but really we're talking about the GSA form and the pledge of collateral. That may not necessarily be a bond, but it's basically like a bond in this example that I'm talking about. So these are basically the laws. These are acts of Congress. One of them in particular, the Trading with the Enemy Act, is in part dealing with the national emergency, the way that they facilitate commerce under the, let's say, bankruptcy or the martial law that's been in effect and the banking emergencies and all these. These are laws that are now a part of the policy of the United States. So my understanding, well, I'm not going to go down that road. I'm not going to talk about I don't want to get too far off the subject. So either way, this is the appointment and authorization. We wanted to keep it lawful, right? So I cited the specific laws that I'm relying on. And there's an attached memorandum of law, which includes all the laws. But here I noted I'm appointing Diane Schwartz as the fiduciary and assigning her the transfer of property to dispose of in the manner set forth here, right? I'm doing this as an executor or a trustee or whatever. I'm not doing this blindly per se, so that they just use general powers and administer the property however they want to, as though you were a surety and a slave, right? So we cite those specific laws. Authorities. The fiduciary is hereby authorized to delegate or subdelegate any of the authorities granted herein to any third party of his or her choosing, provided that such delegation or subdelegation is made in writing. I'm not going to read all these authorities. You can read over them. Basically, it's almost like when you give somebody a power of attorney, you're telling them all the things, all the authority that they have to do with that property. We gave them property, instructing them how we want to use it as a gift to reduce the debt of the United States, and we want to discharge this mortgage obligation that can't be paid for. Surety. This is important. Under surety, you can read all of these, but in section 4 specifically, I added to this: the principal and beneficiary hereby indemnify the performance of the fiduciary in regards to the authorities granted therein. And that's not what I was looking for. Section 3, that's what I was looking for. The principal and beneficiary hereby pledge the following assets as surety to support any and all bonds and instruments enclosed herewith. Assets pledged, enclosed GSA Form 28, New Jersey certificate, that's like a birth certificate. Still wasn't really what I was looking for. What was I looking for? We already touched on it. We took acceptance of their surety bond as collateral to make sure that they wouldn't derogate from the laws of the United States. Duties of the fiduciary, that's like the authorities. Acceptance and refusal, very important. This contract shall be deemed accepted by the fiduciary if a refusal to the appointment, authorities, and duties is not received by the principal at the address given above within 3 days of the postmark of this contract. Any refusal of this contract must be accompanied by a sworn affidavit signed under penalty of perjury and stating that the fiduciary does not have the capacity, authority, obligation, and duty to 1. Set off, settle, and otherwise discharge the account. 2. Accept an appointment as a fiduciary. 3. Negotiate, endorse, or ledger the instruments against the account for the benefit of the beneficiary. 4. Perform the duties of the custodian pursuant to the Form 91. I got to scratch that because I'm not putting the... I'm not sure. Maybe we'll leave that in there. I think I do have the 91 in there. Ledger the information, returns, etc. So these are the terms of acceptance. What's most notable and important is that they're required to respond under penalty of perjury. That is supported by a fiduciary's duty to provide full disclosure and to act in good faith. Okay, here's another important section, right? And why is this important? Because ultimately, if they ignore everything you're doing, you have to go forward the next step towards enforcement, right? So when you have to enforce, the strongest thing I see that you can go after is the bond for 50,000 or 100,000. And when you make your claim, you're going to have to ledger that claim based off of something. What are the damages? So here's where we put this in our contract: liability of the fiduciary. The fiduciary's failure to perform the duty set forth in this contract within the time within the time allotted to perform said duties will comprise the fiduciary's agreement to the following: the fiduciary waives all rights, defenses, and immunities. The fiduciary accepts personal liability up to 10 times the face value of the instruments. Well, one of the bonds with this presentment, the GSA form, they ask you to put the fair market value of the property that's being pledged. In this example, the fair market value is $1 million. So if the fiduciary accepts personal liability of up to 10 times the face, value of the instruments, that's $10 million on a $100,000 bond. It's not going to work. And again, we're not really dealing with the county. right? We're not, because they have an excess liability policy. The county has their own insurance policies. Every layer of this game has bonds and insurance, but that one individual county recording office in your county has a surety bond that applies only to her and nobody else. And that's what we are taking as collateral in this contract. Indemnification clause. The principal agrees to indemnify and hold the fiduciary harmless against any and all liability, loss, damages, costs, and expenses not to exceed $500,000, which the fiduciary may incur, including but not limited to attorney's fees and costs, etc., etc. So I'm indemnifying the fiduciary out of this property that I am pledging to discharge in full acquittance this debt obligation that cannot be paid. So that is the most significant parts of the fiduciary appointment and authorization contract. Then we go down to this memorandum of law. We'll just skim through some of them, some of the most important ones. This is basically HR, no, this ain't HR 192, 73rd Congress, 1st Congressional Record, March 9th, 1933. Under the new law, the money is issued to banks in return for government obligations, bills of exchange, drafts, notes, trade acceptances, and bankers' acceptances. The money will be worth, etc. So this is also demonstrating that we are under reorganization or bankruptcy. This is all a part of the law of the contract, how we're operating. This is an act of Congress stating that there's a reorganization. We're operating under some different type of money system, this debt-based system. Other laws showing that the gold standard was suspended, but even before that, where did we put it in there? So I'm showing you that, the way I'm breaking this memorandum of law out, we're showing that there was a reorganization. We're showing that the gold clause was suspended. Obligation or other security of the United States includes all bonds, certificates of indebtedness, bills, checks, drafts, money orders. And then we get down here, government is pledged to pay in legal tender, principal, and interest. But then we get down here to the U.S. Constitution, the 14th Amendment, Section 2. No state shall make or enforce any law which shall abridge the privileges, immunities of citizens of the United States. If no state shall make or enforce any law that shall abridge the privileges or the immunity, is it a privilege? Is it a privilege to discharge debt? I think it is, because you can't pay for it. And this is based off of something that the government has done, right? So I believe discharging is now a privilege of the people. And anyway, I state as such that it is. If it goes to enforcement, I'm using this right here. I'm saying that this fiduciary, using color of law, has deprived me of a privilege that I'm entitled to as a citizen, right? Now, again, don't get wrapped up because I said citizen. If I didn't state it at the beginning of this video, I'm going to state it again because I do a couple of takes when I make these. But there's rules, and then there's proper discretion knowing when to break those rules, right? If the Constitution is talking about a citizen, I want to be in that fold. I don't want to be a 14th Amendment citizen. I want to be an American citizen. But let's not get off the topic. Section 5B2 of the Trading with the Enemy Act. Any payment, conveyance, transfer, assignment, or delivery of property or interest therein made to or for the account of the United States or as otherwise directed pursuant to this section or any rule, regulation, instruction, or direction issued hereunder shall to the extent thereof be a full acquittance and discharge for all purposes of the obligation. I like this because this is saying any payment, conveyance, transfer, assignment. What do? We just transferred property. We just assigned property, conveyed property to a fiduciary. Property or interest therein made to or for the account of the United States. Well, it was definitely paid to the order of the United States. We pledged it as a collateral, as property for the purposes of discharging the obligation under the statute in the Trading with the Enemy Act, and for the purposes of reducing the debt of the United States, which is under the Bureau of Public Debt. Is somewhere in here. It's one of these laws. You know, we cited the law for it. It's under this memorandum of law somewhere, but I don't want to go through this all day because you can access this template, create your membership at thctrust.org. And this, again, you can adapt this to whatever you're doing, you know, but this is fiduciary appointment and authorization, giving us something that's enforceable. Also, when you go through this memorandum of law, you'll see I have things like the Sherman Antitrust Act, you know, monopolizing trade is a felony. A lot of thought has been put into this memorandum of law because I'm already aware that we've went and cited these laws, and if they ignore them, we're going to have to pursue them for breach of fiduciary duty. So I've been researching over the years what types of things can you really, you know, what types of things basically take public officers off the monopoly board if they're, what is our power, what is our authority. Now here's the things that I know, and that's what I put in here. Monopolizing trade, that's one. False, fraud, of course, but concealing records, dishonesty, those are other things. Violations of constitutional rights, several different things, and that will be the last video that we're going to talk about. We're going to kind of talk about the angles and looking at the enforcement, which is really breach of fiduciary duty, and what would you do, or what do I do if they just ignore the surety bond and they don't record any of the stuff and they send it all back to you, right? Because one thing they're not going to do, I can't say they're not going to do, we can never predict what they're going to do, but the way that we wrote that notice in the very beginning, they're going to send it back to us. And I got to make a note for myself right now because I want to add to that notice. I want to make it very explicit to them that this is private property. If you are not going to perform, you have an obligation to send it back. Why do I want them to send it back? Because one, I don't want them out there making copies of this, confidential stuff, but also I'm going to send it to them one more time and give them a final opportunity to cure before I actually start the process of putting a $10 million claim on their surety bond, right? And why? Because we crossed our T's and dotted all our I's each step along the way, and they refused to respond when they had a duty to respond. All of that due diligence makes our $10 million claim on their surety bond lawful. And what's worse is you can promulgate and publish that claim, and it cannot be challenged, really, because nobody has any firsthand knowledge except for the person who already defaulted and refuses to respond. Why don't they respond? My honest opinion is because, one, they've been playing gatekeeper and slave master too long, and two, because they're so uncomfortable doing something that's brand new that they don't understand and know. But that's not my problem. I'm supposed to be able to expect performance under a constitutional officer and fiduciary. Yo, I hope you enjoyed this video. Make sure to subscribe to thctrust.org. In so doing, you will get, you will be able to join the private Telegram group, which I'm in there like all the time. So you can kind of run something, you could drop something on me, holla at me real quick or whatever. And, you can support by starting the membership on the site. You can also get the Home for Free guide. You got to get that directly from me. It's a $100 contribution. Peace and love. I'm out.